Hi, I'm firearms attorney Gilbert Ambler, and today I'm back to talk about Gun Owners of America's one big, beautiful lawsuit, which is challenging the NFA registration requirements for certain firearms. And what we're going to do today is we're going to go through a quick constitutional lesson, sort of constitutional law 101. We're going to talk about some of the things that I find interesting about the Constitution. Hopefully you find interesting, specifically with how they relate to Congress's power and whether Congress still has the power to regulate and require registration of these certain NFA items. We're also going to run through a quick background of where we are in terms of how the big, beautiful bill went, the way the ball bounced in terms of we weren't going to have registration, now we're back to having registration, but got rid of the tax on these certain items. And we're going to talk about what I think the chances are, where our hopes are, and what defenses the Department of Justice might have when it comes to this lawsuit and the challenge to the NFA's registration requirements for silencers or suppressors, short-barreled shotguns, short-barreled rifles, the things that they removed the tax from. Now, before we dive into this subject, as always, if you have not yet hit that subscribe button, what are you waiting for? Subscribe, like, comment with your thoughts, and share with your friends. That way, you and your friends can keep getting this important Second Amendment-related content. Now, unless you've been living under a rock, you know that Trump's one big, beautiful bill passed. And keep in mind, we've done a couple videos, we've talked about this. As this bill moved through the House originally passed it, removing only the taxing requirement, but leaving in place the registration requirement for suppressors. The Senate then added into the bill the removal of the registration requirement and the removal of the tax for short-barreled shotguns, short-barreled rifles, shotguns that the Attorney General would not find suitable for a sporting purpose. And that was great until the Senate parliamentarian came in and said, this is too far removed from a budgetary function because you're getting into the registration requirements. Obviously, we think the parliamentarian was wrong. Unfortunately, parliamentarian's ruling stood. No one challenged her. No one fired her. And so instead, due to the bird bath, that and the bird's rule, tongue-in-cheek there, that portion of the registration requirement, which was removed, was added back in, and that's the way it finally passed in both the Senate and the House and was signed into law. And so what that did was, and of course that's a good thing, where I'm always happy to give less money to the government. What that did was it removed the tax for silencers, suppressors, short-barreled rifles, short-barreled shotguns. Now, where this gets interesting is as soon as that bill was signed into law, Gun Owners of America and a coalition of some individuals and industry organizations like Palmetto State Armory filed a lawsuit. There's been a bunch of YouTube channels out there that have gone through what the lawsuit itself actually says. It's not the longest complaint ever, nor does it need to be, challenging this law. What I want to talk about today is whether it's likely that lawsuit is going to succeed and what some of those arguments are. I don't just want to read the lawsuit to you. I want to talk about the legal theories underlying it. Because in order for Congress to legislate on an issue, it has to be within the orbit of what Congress has power to legislate on. Because keep in mind, the Constitution reserves powers not granted to the federal government, reserves those powers for the states or to the people. So it's got to be a power granted to the federal government. Typically, there's a couple of powers that are granted to the federal government by the Constitution. One is the power to tax. We know this. Governments need tax to survive. Federal government has the power to tax. Secondly is power over interstate commerce. That's one of the big things that you'll see Congress has power over. Things that affect interstate commerce, meaning items moving between the states. And when you think about why the framers set up the government that way, it makes sense that the federal government, which of course has the supremacy clause to give their laws power over state laws if there's a conflict, makes sense to give the federal government power over items that affect interstate commerce. Otherwise, you would have states doing things that benefited them that would hurt their neighboring states, and the federal government couldn't do anything about it. So those are the main powers. You hear other powers. You're going to hear about things like the power to spend. Congress has the power to spend money, the power of the purse, obviously, spend the money that they tax. Congress also has necessary and proper powers. And this essentially is a way of expanding the strictly enumerated powers. So Congress has the power to tax, They also have the ability to carry out necessary and proper functions to support that ability to tax. So, classic example here is Congress has the power to establish the federal banking system, and the federal banking system supports their power to tax and their power to spend. So, not directly granted the power. The Constitution doesn't say you can have a Federal Reserve and establish a federal banking system, but it's a necessary and proper part in order to carry out a function that has explicitly been granted to Congress. Now, I know I'm probably getting a little boring here because we're getting into the constitutional weeds, but it's important because back in 1934, when the National Firearms Act was passed, it was passed as a taxing provision. And there's case law out there that upholds the National Firearms Act based on it being a taxing power. Congress has the power to tax, and all the other regulations stem and relate to that taxing power. Now, the big argument that GOA, Gun Owners of America, has made, and I want to talk about how it's going to play out, is they've made the argument that, and there's case law to support this argument, that if there is no funds being raised by the tax, it is no longer a taxing power. And intuitively, I think that makes perfect sense because when you really think about it, if Congress could simply slap a tax on something, even if they raised no money with the tax, it would allow Congress to literally control just about anything. I mean, you name it, they could create a way to tax it even if it didn't raise money and then say, we get to regulate on that subject because we've assigned a tax. So given that there is no longer a registration fee for the tax, no longer a $200 tax stamp required. You still need the stamp. It's just a $0 tax stamp for suppressors, short-barreled rifles, short-barreled shotguns. Given that that is a $0 tax, does it really fall within the taxing power? So that's the argument that GOA is making. It's very simple, very straightforward argument. What is the DOJ going to do here? Now, this is where things get interesting because I think the DOJ has a couple of things that they could do. Number one, which would be really incredible, is they could come back and enter some sort of, and we've seen them do this in things like the forced reset trigger lawsuit, they could come back and enter some sort of consent decree agreeing with Gun Owners of America and settling the case. And of course, and as some of you know, I've represented Gun Owners of America on things in the past. And so, I don't want to have a conflict of interest there, but you might consider being a member of an organization that is fighting these lawsuits because as a member, hopefully if there's injunctive relief or some type of settlement, hopefully that will apply to members of these organizations. Something to think about, right? Now, if the DOJ does not settle this lawsuit, if they don't try to come to some sort of agreement, they're going to defend it. And if they defend it, what are they going to argue? First thing they're going to do is they're going to attack this idea that the $0 tax is not a proper taxing requirement. I suspect that they'll make arguments on that point. They'll potentially even make arguments that because the tax could be raised again in the future, which is something we should be worried about, that it still falls within their taxing power. Again, as I discussed a minute ago, this could potentially get us into an area where we are talking about things that go way out into left field that Congress could legislate that the founders never intended them to legislate. The second thing that they might do is they might fall back on one of their other powers, which is interstate commerce. Because although the entire NFA is built on the taxing power, Congress, when they authored it, apparently thought some about the power over commerce, because with the commerce powers, they have some typical commerce power language included within the National Firearms Act. For example, 26 USC 5861J talks about making it unlawful to transfer, deliver, or, and I'm missing a word here, transfer, deliver, and we'll put the law up on the screen for you, a firearm that has not properly been registered under the National Firearms Act in interstate commerce. So what they're doing there is they're starting to tie the law not only to their taxing power, but also to their power over interstate commerce. And the reason this is interesting is it sort of gives them a fallback argument as to why this is a proper power that they have. And I will tell you, some of the case law about the commerce power is really, really terrible. And we've seen recent fights on this as to whether the NFA can be sustained as to commerce power if there is an item that never leaves the state. For example, if someone in Texas uses Texas steel to make a suppressor, sells the suppressor in Texas, and it never leaves the state of Texas, can the federal government still regulate that? And unfortunately, there's really bad case law. This is one of those cases that, as you go through law school, just upsets everyone who doesn't really love the federal government. I guess it probably didn't upset the kids that wanted to be prosecutors, but it upset me. A case called Wickard v. Filburn from the 1920s or 1930s. And in this case, this ancient case where they sort of expanded the Commerce Clause, what they did was at that time, there was a federal law limiting how much wheat a farmer could grow, establishing limits. And I guess it was trying to control the market of wheat. And at that time, a farmer grew more wheat than he was allowed. And his argument was, well, the excess wheat is not leaving the state. It's just for me. It's for my family, my personal consumption. And it went all the way up to the Supreme Court. And the Supreme Court, in what I thought is a very ridiculous decision, said, nope, still a proper exercise of Congress's power over interstate commerce, even though the wheat is being grown and consumed on the same farm, because by allowing that farmer to grow over his limit and then use it himself, he doesn't have to buy wheat from another person, and therefore it still affects interstate commerce because he's not engaging in interstate commerce to buy his wheat. And so that same argument is the argument that gets used to justify in modern courts when a suppressor, for example, is built in Texas, never leaves Texas. Congress, although that suppressor is within one state and one state only, you would think Congress doesn't have power over it. The DOJ has historically argued, yes, they do, because that item is being made and consumed in Texas, it means someone's not buying a suppressor that is theoretically made in another state, and therefore it's still affecting interstate commerce. So again, I know we're getting into some confusing portions of constitutional law, but to me, they're interesting. I hope they're interesting to you, and it's how some of these arguments are going to play out. If you enjoyed this content, go ahead and hit that subscribe button for us. Until next time.